Welcome to part 2 of the debrief on seeking and negotiating employment. In the second part, we're continuing to look at the examples of whether certain actions or communications by the Department of Transportation employee meet the definition of seeking employment. But in the next few examples, the actions or communications are ones initiated by the prospective employer. Next slide. So let's look at example 4. After seeing the DOT employee's social media post indicating interest in jobs with self-driving car companies and the employee's resume, a representative of Company A, a self-driving car company, emails the DOT employee to ask about their qualifications. The DOT employee does not respond. What do you think? Is the employee seeking employment? The answer is no. If a company reaches out to the employee and says, I saw your post, that is considered an unsolicited communication to the employee. And the employee will be seeking employment if they respond with anything other than rejection. But since the employee here didn't respond, they're not seeking employment. Next slide. I'll read the 5th example. The employee in their DOT work interacts with Company A. During those interactions, Company A says it would love to hire the employee for a specific position. The employee responds by asking if the position would involve work on developing self-driving cars. Do you think the employee is seeking employment here? Yes. This is seeking employment because Company A made an unsolicited communication to the employee, and the employee's response is to ask a question about the employment opportunity rather than to reject it. Next slide. I'll read the 6th example. So it's the same example as number 5 above, but the employee responds. So in other words, the employee works with Company A in his agency work, and Company A says it would love to hire the employee. But this time the employee responds that because of their DOT work involving Company A, they cannot pursue the job opportunity now, but they will be in touch after the matter is over. And that's the matter involving Company A. What do you think? Is the employee seeking employment? The answer is yes. Under subpart F, they are seeking employment. Simply deferring the decision about the job opportunity until after the employee completes an assignment affecting the prospective employer is not a rejection of the opportunity. So that response would amount to seeking employment under subpart F. Next slide. So we've completed the examples that deal more with the prospective employer's actions and the employee's response in terms of whether those actions and responses meet the definition of seeking employment. Next slide. So what response by the employee would effectively reject the possibility of employment? And what actions or non-action by the prospective employer would effectively end the seeking employment recusal under subpart F? Let's look at examples 7 through 9 on this slide. Example 7. The employee in their DOT work interacts with Company A. Company A tells the employee it would love to hire them. The employee responds that for ethics reasons, they can't talk about employment until they leave government. Does the employee's response effectively reject the possibility of employment? Yes. So the employee is not considered seeking employment if they give that response. And in the related training on seeking and negotiating employment, I gave you other examples of statements that effectively end the seeking employment, like, I've determined that I won't be able to pursue this job opportunity. I will remember your interest if I ever decide to leave government. Next slide. Example 8. After the DOT employee sends their resume to a self-driving car company, 2 months go by with no response from the prospective employer indicating interest in employment discussions. So we know that sending a resume to a company is seeking employment. So the employee is seeking employment as soon as they send the resume. But after 2 months go by with no response from the prospective employer, is the employee seeking employment? Under subpart F, the answer is no. The employee is no longer seeking employment when those 2 months go by with no response from the prospective employer. And that the provision in subpart F that explains this is 2635 603 B2 double little I. Next slide. I'll read example 9. The DOT employee interviews with a self-driving car company and gets called back for a second interview. After the second interview, the company informs the DOT employee that they were not selected for the position. What do you think? Does that rejection by the prospective employer end the seeking employment recusal? Well, technically, yes. The employee is not seeking employment within the meaning of subpart F after a prospective employer rejects the possibility of employment, and that you can find that in 2635 603 B2 little I. Next slide. But this is one of the situations where subpart F provides agencies with some discretion regarding how the recusal plays out. Specifically, where the employee is no longer negotiating for employment because they didn't ultimately get the job offer, or the negotiations started but fell through, the agency has the discretion to require the employee to continue recusing, even though they're technically no longer seeking employment, on the ground that after considering the facts and factors listed in 2635 502D, the concern that a reasonable person may question the integrity of the agency's decision-making process outweighs the government's interest in the employee's participation in the particular matter. And you can find out more in section 2635 606B. So in example 9, the employee is no longer seeking employment because they were not selected for the position, but the agency could use its discretion under section 2635 606B to decide that nonetheless, the employee needs to continue recusing. And that's why I put a star next to the X. So just to recap what we've done so far, our fictional DOT employee initially asked us a very broad question in exercise 1 about what their ethics requirements are regarding job searches. In response, we've given the employee an overview of subpart F and the requirements. The employee came back to us with more information about their job search in exercise 2, but it really wasn't enough information to help them determine whether they'll have a recusal requirement under subpart F. In exercise 3, we asked for and received more information about what they work on at their agency within DOT, and we discussed how that work may affect their prospective employers. And then in exercise 4, we looked at examples of how their job search actions may go and whether those actions and exchanges amount to seeking employment. So hopefully this gives you practice in applying and working through the 2 elements required for the subpart F recusal. And it also gives you practice in addressing an employee question that is missing some of the information that you need to advise the employee on subpart F. Next slide. Before we move on to the Stock Act exercises, let's go back to exercise 3, part 2. If you recall, when I gave you examples in exercise 3 of what the DOT employee might work on, where the employee was looking for jobs with a self-driving car manufacturer, the examples I gave were specific party matters, so matters involving named parties. The complaint review work was one of the description of duties, and then the software contract oversight work. Under subpart F, if the employee's complaint review work or software contract work affects the prospective employer's financial interests with whom they're seeking employment, the employee has to recuse from such matters. So what would happen though if the employee's work for the agency involves matters that do not involve specific parties, like policy and regulatory matters? So let's say, and now I'm reading this slide, the employee says, I develop policies, regulations, and standards for automated driving system safety. Such policy and regulatory work would likely affect a car manufacturer as part of a discrete and identifiable class of persons. So does that mean that the employee will have to recuse from that work? You would think so, right? But Subpart F does draw a distinction between specific party matters and particular matters of general applicability in terms of the recusal requirement. That said, it's not much of a difference that this distinction draws. There's a very limited exception to the Subpart F recusal requirement if the employee's work involves matters of general applicability. You can find it at 2635-604A2, and per that exception, where an employee participates in policy or regulatory matters or other matters of general applicability that would affect the prospective employer's financial interests, the employee may participate in those matters if the employee's only communication with the prospective employer has been to submit a resume and the prospective employer has not responded with indication of interest in employment discussions. So this is a pretty limited exception. And it's not that you don't have a recusal when you work on particular matters of general applicability and you're seeking employment with someone affected by those matters. It's just that under this exception, you technically don't have to recuse from such matters until you hear back. Next slide. All right, we are now on to the Stock Act notification requirements, which is the other component of Subpart F besides the recusal requirement. And these are notification requirements that apply only to public filers. And these notification requirements apply if the public filer is negotiating for future employment or compensation with a non-federal entity or has an agreement for future employment or compensation with a non-federal entity. So these notification requirements technically don't kick in at the seeking employment stage. They only apply to the negotiation and agreement stage. And specifically under these notification requirements, the public filers must notify their ethics official of the negotiation or agreement within 3 business days of the beginning of the negotiation or agreement. And the filer must also notify their ethics official of their recusal requirement when there is a conflict of interest or appearance of a conflict with the non-federal entity. And the requirements for these notifications, like that must be in writing and signed, and what those notices should include are discussed in Subpart F, as well as in several legal advisories that OG has issued, like LA 1201 and LA 1306. And those legal advisories suggest a format to use for the notifications. Next slide. So let's see in exercise 5 how these Stock Act requirements would play out with our Department of Transportation employee who wants to work for a company that is involved in self-driving cars. So let's say the employee is a 278 filer and they take one of the following job-seeking steps. Example A, the DOT employee sends their resume to a self-driving car company. Do they have a Stock Act notification requirement regarding this car manufacturer? Well, we know that the employee is seeking employment here because they sent their resume, so they have a recusal requirement. But technically, they're not required to file Stock Act notifications because they're not yet negotiating for employment. That said, per Subpart F and the legal advisories that I mentioned, public filers are encouraged to file the Stock Act notification and recusal statement before negotiations have commenced and before an agreement of future employment or compensation is reached. And that's to facilitate receiving advice from their ethics officials. And if they choose to file early these notifications, that notification would count once the negotiations or agreements have been reached, as long as the early notice contained everything that the notice needs to contain. Now let's look at example B on this slide. The DOT employee emails their friend who works at a self-driving car company about job openings at the company. The friend responds that there is a job opening, but prior work experience with a specific technology is required. The DOT employee provides their resume and explains prior relevant experience. Do you think under these facts the employee would be required to file a Stock Act notification? The answer is yes. This exchange appears to meet the definition of negotiating for employment, even though an interview hasn't happened yet. And negotiating for employment is defined in subpart F, just want to point that out. And the employee must file the Stock Act notification of their negotiations with the company, as we said, within 3 business days of beginning the negotiation. And if there's a potential conflict, they should also file the recusal statement. And just note that the employee does not need to tell their supervisor that they're negotiating for employment with this self-driving car company unless informing their supervisor about the recusal is necessary to carry it out effectively. Next slide. In example C on this slide, the DOT employee isn't going to look for jobs with self-driving car companies after all. Instead, and now I'm reading example C, the DOT employee is a talented calligrapher and has informally designed friends and family's event invitations for years. The employee plans to retire from DOT and turn this calligraphy hobby into an invitations business. Before retiring, the employee will contact local businesses and other potential clients to negotiate contracts to design invitations for their special events. The employee will not, however, start performing the contract work until after retirement. Under these facts, would the employee have to file a Stock Act notice? Yes, he has to file a Stock Act notification. And that's because the Stock Act notice requirements are not applicable only to traditional employment situations, but also to compensation for services to be rendered following termination from federal government employment. So even if the employee's efforts here to find clients for his invitations business may not sound like future employment because these would be future clients, not employers, his engagement with these potential clients about future compensation would be subject to the Stock Act notification requirements. Next slide. We're now at the last example and exercise of this debrief. Example D on this slide is a variation of example C on the previous slide. So the same facts as C, the DOT employee will turn his calligraphy hobby into an invitations business. But instead of retiring, the employee will conduct their invitations business while still employed by DOT outside of government work hours and not using government resources. The employee will contact local businesses and other potential clients to negotiate contracts to design invitations for their special events. So will the employee have to file Stock Act notification under these slightly different facts? No, he won't have to file Stock Act notices because the notification requirements apply only to negotiations or agreements for future employment or compensation for personal services. So future here means starting after the employee leaves government. In other words, the job or work that the employee is negotiating for needs to start after the employee's federal employment ends, or the compensated services have to be rendered entirely after termination of federal government in order for these notification requirements to be triggered. Next slide. We've completed all the exercises in this debrief on subpart F and its 2 components, the recusal requirement and the Stock Act requirements. And I appreciate you joining me. Should you have any questions about subpart F, please feel free to get in touch with me or with your agency's OGE desk officer. Thank you.